Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we talk about your questions and we answer your comments and questions. So welcome everyone. Let's see what's been the most recent, questions and the recent comments. Renee Gibson says, you know your stuff. And she's responding to the video Ceiling Collapse with a Fusion and Knee Scope that we did, where we talked about one specific case with a fusion and a knee scope with a ceiling collapse. And then there was an appeal. There was a pretty good verdict. I think it was close to $2 million, and there was an appeal, and we analyzed that and all the case law as to how the liability was actually left intact, and most of the damages verdict, except for I believe $15,000, was also left intact. $15,000 in lost wages was removed because of an error, but other than that, so they kept the verdict. So that was a good, interesting case, and they explained the analysis as to why. And so thank you for that. Thank you for saying that. Oh, okay, and then Latoro asks, an Uber accident where it's progressive, and then the other guy said it was all his fault. Can it be less than a year? I mean, it's possible, right? It could definitely be less than a year. It just depends on the lawyer, right? It depends on the severity of the injury too. If it's like a really small injury, you could just get treatment for like 3 to 4 months. Then you're all done. And then at that point, the lawyer sends a settlement opportunity letter or a settlement package, gives them another like month or two to review, picks up the phone, settles the case. It's usually gonna be a smaller amount, maybe like 10, 15, 20,000, but it's quick, right? If you have a bigger case where it's like surgeries, bigger like Uber, let's say $1 million, and you're going after millions of dollars, it's going to take maybe 2 years, 3 years. It's going to take longer, but then you're also looking at a bigger amount, millions or hundreds of thousands. So it just depends on that, the injury, and also the lawyer handling it. So I can't tell you exactly how long it's going to be, but definitely it could be less than a year. It's possible. Sach asks, does an attorney get paid up front? For example, my attorney got paid $1.5 million between 2017 and 2020, paid by the California State University. Is this amount considered coming from economic damage recovery for the plaintiff? I don't know. I don't know what kind of case that is. Usually the way it works in personal injury is that first you have to win the money, right? Win, like, for example, $1 million for the client, then you get a third of what you win, which would be like 300,000, 333. That would be the way they get paid. But if they're getting paid by like a state university, why would they be paid? Is that because they were retained by the university to do something like a contract? So every type of work is different, so I don't know what kind of case that is. And then she also asks, would this amount paid be included in determination of a settlement now? So your attorney was paid up front. I don't think so. Why would the attorney's fee be included in the settlement? Usually not. But I don't know what kind of case that is or why the attorney would be paid if it wasn't resolved. It's strange. It doesn't make sense. Pegasus asks, how long does it usually take for you to get around to text messages? I try to respond like usually the same day, maybe the next day. The only thing is when you text me, just include your name, your phone number, include like a little statement of what happened. It doesn't have to be long, just 1 or 2 sentences, just the facts and who you feel is at fault. And include your injuries. Like, it doesn't have to also be everything, right? Like, you don't have to say, I went to physical therapy, I went in a hospital, I went to an ambulance. Just give me the diagnosis. Like, for example, at the end of the whole case, I had a broken arm, or at the end of the whole case, I had a C3, C4 herniation, which required surgery. That's all I need, just 1 sentence as to what the injury is. And then, and tell me your city too. Like I'm in Kentucky, or I'm in whatever, like New York City or Miami, Florida. And then I can just schedule a call. Oh, and tell me like when you're available, and then I'll just schedule a call. I'm actually probably gonna change it soon. Maybe I'll add one of those Calendly links, then people could just, and I'll put my available times, then people could just book directly. It'll be easier, but I haven't done that yet. I'll probably try to do that within a week or 2. And then, yeah, I was gonna try to do a bunch of calls today actually, because it's Friday, and I was in depositions all week, so I was a little busy. And then ES Sadia Ben Fare asks, hey, Mr. Frekhtman, I would like to know why the defendant's lawyers wanted to do more depositions after my lawyer filed a note of issue, and also they don't want to settle. Is that just wanting to drag the lawsuit longer, or what do you think? Do all defendants in personal injury do the same? Thanks. So yeah, usually they can only do one deposition of you, and there's actually a 7-hour rule. They can't go beyond 7 hours for one deponent, right? But if you have a new injury, like for example, if you have your deposition, then you go out and you get a surgery for like your back. Well, now they could do a deposition just about the surgery. Usually those are shorter, like, an hour, 2 hours. How long could they really take with just one surgery? But it's a new injury, so they're entitled to a deposition as to that issue. Otherwise, they would not be entitled to a deposition, an additional one. So your lawyer could just subject and they would not be entitled to it. Okay, and then Lolo Cook says, what does it mean when the lawyer tells you your case is high value? I have over 159,000 just in medical bills so far. Right, so I guess like that means that to him or her, to your lawyer, it's like one of the higher value cases. But, for like one lawyer, 159,000 could be high value because all his other cases are 5,000. But for another lawyer, high value is 1.59 million, right? And for the third lawyer, hey, maybe 15.9 million is high value. So it's all relative. So what you should really ask is, what range do you think the monetary value will be? Not just at high value, right? Because 159,000 in medical bills, you would think you'd be entitled to at least like, 700,000, 800,000, maybe more, maybe 1 million in total. But I don't like to calculate value based on medical bills. I think that's really not the way to do it. I think you have to look at the injury, the diagnosis, the damage to the person, the entire human story. And then, even if your medical bills are low, like 20,000, the case could be worth like 700,000, 800,000 because the injury is there and it has an impact on your life. So I would just find out what they actually think the case is worth if they're willing to tell you that. Dan says, is it a red flag when your attorney doesn't discuss value of settlement? I'm almost at the end of my case. Thanks. Yeah, I've done some videos about that. I think one of the videos was called Why Lawyers Don't Want to Tell You How Much Your Case is Worth. And I think, to give away the ending of that video, I think the main reason, I gave a few different reasons, but one of the main reasons is because they negotiate the old school way, right? That everyone's been negotiating since like the 1930s or whenever, which is, the defendants have a lot of money, let's say $1 million. They want you to make a demand. They call and, say you have a serious injury. They make a demand. They say, I want 700,000. The insurance company laughs at them and says, well, I'll give you like 15. That's way too high. You have to come down. And then, so the reason they don't want to tell you how much your case is worth is because they don't know how far down that insurance adjuster and the defense attorney is going to drag them, right? They start at like 700 or even $1 million. And then the guy's offering them 15. And then, they have more than 15. But like they're calling all the shots, right? They're playing their game, meaning the insurance company and the defense lawyer, and they might come up to like 75, but they might just not want to pay any more than that. And the only way to make them pay more is to take it to trial. But a lot of lawyers don't want to go to trial. And that's why they don't want to tell you what it's worth, because they don't know how far down from their initial demand the insurance company is going to drag them, whether it's going to be like 30 or 70 or 125 or whatever it is, right? So I do it the opposite way. I send them a settlement opportunity letter. I review the case myself and I put what I think the case is actually worth. Like for example, if you have a fusion, I'll say, okay, it's worth, let's say $2 million. Pay me the $2 million. You have 30 days. It's going to expire, today is what, April 25th. So it'll expire May 25th at 5 p.m. If you don't pay the $2 million, that's totally fine. But guess what? May 25th at 5:01 p.m., it's not going to be 2 million anymore. It's going to be 3.5. And then I'm going to keep stepping on up until I get to the jury and I just do it, right? And I go to trial. And I think that just works better because they get scared, they pay you your number, or sometimes they don't pay you your exact number, but they pay you something close. So if you're asking for $1 million, they might pay you 700. And I think that's a better way to negotiate. I don't see the point of the whole demand. I think the whole system of you making a demand, right? It's almost like you're begging, and then they are giving you money, like whether it's ridiculous money, even if it's low, they're like, oh, but it's real money, 15,000, 20,000, 70,000. And then you're like forced to go down. And as soon as you go down, guess what? As soon as your demand becomes, let's say 150, well, guess what? All the other money, if it's $1 million policy, all the other money is gone, right? The 850 is gone. So you've just given them a gift of $850,000 because you're demanding 150. And guess what? They don't even want to give you the 150. Then they start bringing you down from there. It's like, I don't like to play that game. It's just, what's the point? I think the whole system is skewed in their favor. The insurance companies, they make like $93 billion a year. Why do you have to play their game? Just play your own game. Go to court, get the number from a jury, and just enforce the judgment. That's how a lot of the top lawyers do it. And like, for example, the person that wrote the book on this system, he just did a few trials. He had the first trial, 34 million, second trial, 50 million, third trial, I think it was like 40 something million. So that's the way they do it, you know, like, well, why do you have to lowball? So yeah. So if they don't tell you what it's worth, that's a red flag in my book. Burnt's asks, what's a calendar call? So that's just when they call the calendar for like the court, you know, whatever. They have compliance conferences, they have motions, they just call it like, you know, Smith, Jones, you know, number 1 on the calendar, number 2 on the calendar, just call the calendar. It's not really anything more than that. And then Diana Hansen says, hello, my name is Diana and I had a car accident almost 2 years ago and I got 2 bulging discs and 2 herniated from the L2, L3, L4, and L5. My lawyer is suggesting to take the amount of $75K, but I'm in pain all the time and have not been able to work for the last 2 years. I've gotten from a neurologist to a therapist to an epidural injections as well as pain management injections to therapy, but nothing seems to work. My neck and arms hurt, my lower back, it's burning and ready to pain through my legs. I don't know what to do. Should I go to court? Yeah, I mean, the best thing to do in a case like that, just give me a text. That's one of the examples where you have like a, you know, a whole complicated situation. You have a case, you're not sure what to do. So if you text me, I'm happy to chat with you and give you my opinion. If it's in New York, maybe I could help you if you need help, or I could refer you somewhere. Like if you are not happy, your attorney's saying, look, I'm not going to go to court. You got to take 75. I'm not doing anything else, but you don't want 75. I can get you a second opinion. Maybe another attorney who's like a stronger trial attorney in that city, right? Whether you're in Miami or Los Angeles or wherever you are, maybe that attorney that I find will say, hey, you know, I'll go to court with you and this could be 750, not 75, right? Maybe it's worth a second opinion. It's free. So I'm happy to help. Just text me 347-566-9595. And then Ace says, I was hurt while working by another employee. So does that mean I can sue for this as personal injury, or would it only be workers' comp? Right, so you have to like really look into, I'd have to know like what happened, where you were, what state you're in, all the details, but usually workers' comp is like when you cannot sue your employer, right? Because you get workers' comp benefits, usually. In some states you can, like I heard in Texas you can, but usually you cannot, right? So if you can't sue your employer, if you were hurt and it was only caused by another employee, that would be like, you know, an agent of your employer. So that would be the same as suing your employer. So you can't do that. That would be workers' comp. But if any third party was at fault, for example, you worked for like an employer, right? But into your building that comes ABC Cleaning and they're not part of your employer and they're cleaning, they're mopping, they leave a puddle. Now you could sue ABC Cleaning, right? Any third party that did anything wrong, you could sue the third party, and that's a third party personal injury lawsuit. And you could also get workers' comp, which is first party, right? Workers' comp is lost wages and medical bills paid. But then you could also sue the third party. So that's usually how it works. Joe Lovejoy says, happy I saw this video referring to how much a truck accident lawsuit and settlement value. I was hit by a flying semi-tire and rim that actually crossed over the median and totaled my car and injured my neck. I have been going to physical therapy and getting injections for 3 months. How much would you ask for if it was totally unavoidable by me? I was actually driving up the interstate, minding my business, and a tire and rim crushed into me and changed my life. Yeah, I mean, it's better to text me for something like that. I'd want to like speak with you and get all the facts, like where you are, right? What the injuries are, a little bit more detailed. But remember, like, I think you're confusing two different things, because you're saying how much would you ask for, and then it was totally unavoidable by me. But being unavoidable by you goes to liability, right? That's the question of who is at fault. So you could win on liability and be not at fault if you show that the tire needed like repair or maintenance, maybe it was, you know, had to be changed, whatever the reason was that the tire flew off. So that makes them at fault, the trucking company, right? But then the question of how much you're gonna get, it goes to damages. So that depends on your injuries. Like, for example, you said you injured your neck, but what's the actual diagnosis, right? What's the injury? Is it a fusion? Is it a herniation? So I'd have to know that, because if you just had like a small injury with physical therapy, Even with injections, I'd have to then know what type of injections, right? Because there's like many different types. There's epidurals, which may be worth like 150,000, but other injections could be worth like nothing or 10,000, right? Or even nothing. So, you know, it's hard for me to say. So the best thing to do would be to text me, 347-566-9595. Here's a question from Charles. He says, not knowing the Appeals Court of California, and he's referring to the video about the $50 million Starbucks case. He's saying, there's also the possibility that the amount could be lowered, case tossed, or sent back to the lower court for a retrial. To me, the initial offer was a safe one, knowing the appeal's outcome could be detrimental for the plaintiff. Why would the plaintiff not accept the bird in the hand, since the bird in the hand seems like the size of an ostrich? Yeah, I don't know what offer you're talking about, because, oh, he says he's talking about the $30 million offer. Yeah, well, no, I explained in the video why he didn't accept it, because he said, I'll take 30 million, but you have to send an email to all the other Starbucks, you know, all over the world, and just tell them that, please, like when you do the cups, just put the cup all the way in the holder, right? Because if they don't go all the way in the holder, then guess what? Like the cup is just like freestanding and it's gonna fall over, right? And it's gonna burn someone. It's a medicine ball, 200 degrees, almost boiling. So that's what, and then Starbucks corporate said, no, we're not gonna send the email. So he said, okay, if you're not gonna send the email, then even though it's 30 million, and the client, being very brave, agreed not to take $30 million because he didn't want other people to get hurt. And so he took a risk. He could have been zero, but he got 50 million. So he actually, the risk paid off. And 3 jurors were crying and they wanted to give 125 million. So that's just what happened. But in the beginning, they were going to take 13 million, and he agreed to take 13 million. But again, Starbucks said, well, our deductible is like 5 million, and we don't want to pay 5 million. We don't think this is worth 5 million. See, the deductible, the self-insured retention, the way that works is first Starbucks has to pay 5 million, right? Once they pay 5 million, then the insurance kicks in, right? And he wanted 13, so they would have to pay 5 and then get 8 in insurance. And they said, we're not going to pay 5. The most we have is 3. And this all came from Starbucks corporate. So Starbucks corporate made these decisions as to why. They could have settled for 13. They could have settled for 30 if they just pressed a button and sent an email. So I don't think you should be blaming the plaintiff taking the money. I think he actually did a really valiant thing. I don't really understand your reasoning, but you know, everyone of course is entitled to their own opinion. He's saying, why would the plaintiff's attorney even test the appeals court? And why would the plaintiff himself be foolish enough to allow his lawyer not to accept the offer? What would happen? The appeals court sided with the defense. There's not really, I don't think there's any, I think it was paid already. I'm not sure, I have to check, I have to ask. But I know one of the verdicts was paid, maybe the first one. Because this is the lawyer who got 3 in a row, right? 34, 50, and then the third one was like 40 something. I think the first one was paid already. Maybe not this one. I'm not sure. I have to go back and look. But I don't know. It's his decision. He just, you know, I guess he's like a ballsy lawyer. He didn't want to, and the client was pretty ballsy too. The client was just like, look, I'm just going to do it because I don't want other people to get burned. Sometimes, you know, you got to think of the greater good, right? It's not just me getting 30. Of course, you know, getting 30 million is something, but he's also scarred for life. He had like his penis burned off. That's not exactly, you know, and then instead of pleasure, he feels pain. It's a terrible thing. But, you know, everyone makes their own decisions. And then he says, was this the actual footage of the event? Yeah, it was. This was a CVN trial with the Courtroom View Network. So this was actual footage of the trial. You could actually watch the whole trial. You have to subscribe to CVN, but you could watch the entire trial. And then he also says, I could swear that the vehicle was in motion before the beverages were secured. If that's the case, wouldn't the plaintiff be responsible? No, the vehicle wasn't in motion. The vehicle was standing there for 2 minutes. It took 2 minutes to get the third cup. I think what happened was 2 cups were in, but it took Starbucks like really long to get the third cup. So once they got the third cup, and that's the one that they didn't put in the holder all the way, they just kind of put it a little bit. So it was like, you know, free falling in the air. Then she gave it to him and it just fell right over. After it fell, he went in motion. I guess he was just shocked or he was painful, but that was after it fell. So yeah. So this is an example of someone you would not want on your jury. This commenter, Charles. Don't put Charles on your jury. Unless you're a defense lawyer, then definitely put Charles on your jury. Okay, everyone, have a great day. Please like and subscribe to our channel. We are here for you. All the best, and have a great day. And if you have any questions, just leave them here. And we do these like once a week where we answer your questions. We're also going to do a bunch more lives. This week I didn't get to do too many because I was in court and in depositions, but in the future, we're going to get back on it. Okay, have a great day.